just want to organize myself as well, Mr. Stefan. My name is okay. Yes. Yes.
Case number Regional Court 44620B, State versus Julius Malema. The date is the 16th of April 2026. The parties are as follows. Presiding officer Mrs. E. Qualify, Public Prosecutor Advocate J. Caesar, Defense Advocate L. Julius SC, Advocate T. KuGompo SC, instructed by the Advocate Attorney. Our clerk is Mr. Chambeni. Yusuf Liam, accompanied by my boss, the Director of Public Prosecutions, Mr. Barry Madolo. I will have at least one assistant.
I have to object, I still have none. Thank you. Okay, let me get comfortable. Sorry, Advocate Caesar, state ready to proceed and to note sentence. State ready to note sentence.
Yes, please.
No still photos, please, by the media or anyone. Advocate Otis, defense ready. Thank you. Advocate Nkugatobi. Thank you. This is the one I need. I don't need these ones. Let me just ensure our record is there. Okay. Then the court is ready to proceed with sentence in the matter of Julius Malema, hereinafter referred to as the accused. Mr. Malema, please be seated for the duration of the sentence. As judgment, the court can leave no stone unturned, so we'll arrive and I will tell you when to stand up. Thank you. Just as courtesy then, for the state appears Advocate Caesar and the defense being Advocate Odes and Advocate Nkugatobi as instructed by Ian Levitt attorneys. The others were mentioned and acknowledged on record yesterday. And as stated, the court will proceed with sentence. The accused before court was convicted of 5 counts. Count 1, contravening Section 3 of Act 60 of 2000 of the Firearms Control Act, read with the provisions of Section 1, 103, 117, 120, in brackets 1A and 121, read with Column 1 of Schedule 4 of the said Act, being the unlawful possession of a firearm. Count 2, contravening Section 90 of the Firearms Control Act 60 of 2000, read with the same provisions mentioned in count 1, being the unlawful possession of ammunition. Count 3, contravening section 120 subsection 7 of the Firearm Controls Act 60 of 2000, being the unlawful discharge of a firearm in a built-up area. Count 4, contravening section 120 subsection 3C of the Firearms Control Act 60 of 2000, being the unlawful failure to take reasonable precautions to avoid danger to a person or property in circumstances where it created a risk to the safety or property of the general public. Count 5, contravening section 120, subsection 3B of the Firearms Control Act 60 of 2000, reckless endangerment to a person or property. The applicable penalty clauses as invoked by the state and in terms of section 121 of the Firearms Control Act 60 of 2000, with specific reference to column 1 and schedule 4 of the said act. For record purposes, the court will place them on record. In respect of count 1, it is a maximum of 15 years imprisonment. In respect of count 2, a maximum of 15 years imprisonment. In respect of count 3, a maximum term of 5 years imprisonment. In respect of count 4, a maximum term of 5 years imprisonment. In respect of count 5, a maximum term of 5 years imprisonment. In essence, the various sections invoked by the state, as read with each count, means the following. I deem it necessary to state all this 103s. I'll give a brief explanation. Section 103 of the Firearms Control Act 60 of 2000 deals with the crimes and offences giving rise to unfitness inquiries by courts after conviction or sentence of any of the offences as mentioned. Section 121 of the Firearms Control Act states that any person convicted of contravening any of the sections mentioned in column 1 of Schedule 4 may be sentenced to a fine or to imprisonment for a period not should be exceeding the period mentioned in column 2 of the said schedule. Section 120 of Act 60 of 2000, as invoked in each count, refers to the offences, penalties, and the administrative fines applicable. Section 151 of the Firearms Control Act 60 of 2000 states that despite any law to the contrary, any magistrate's court has jurisdiction to impose any penalty provided for in terms of the said act. The court deemed it fit to explain the relevant section invoked by the state in each count for clarity purposes only. It should be noted, and it is well known by this stage, that the provisions of Section 51, subsection 2 of the Criminal Law Amendment Act 105 of 1997 is not applicable in the matter before court, as the section was not invoked by the state in the charge sheet at the commencement of the trial. Therefore, the accused was not warned in terms of the above-mentioned section. It merely means that instead of a minimum sentence of 15 years applicable in respect of counts 1 and 2, the state invoked the penalty clause as contained in column 1 of Schedule 4 of the said act, which prescribes a maximum penalty of 15 years imprisonment. I trust this explanation is understood and the reasons as to why the minimum sentence is not applicable, and that the defense does not need to show compelling or substantial circumstances for the court to warrant a deviation of the minimum sentence legislation. Plainly stated is one of semantics, the one dealing with a minimum of 15 years, the second with a maximum term of 15 years imprisonment. With regards to the maximum sentence, the normal principles followed by courts when sentence is considered is therefore applicable. The above charges relate to the incident relating to the EFF, or the Economic Freedom Fighters' 5th birthday celebration held at Sisa Dukashe Stadium, Mtansane, on the 28th of July 2018. The incident led to the arrest of the accused and his subsequent appearance in court on 27 November 2019. Thereafter, as a result of the COVID pandemic which the country faced, the accused appeared for the first time in person before this court, and you'll need to bear with me here, on the 29th of March 2021. on which date a trial date was then secured. The trial date for the matter to proceed was 27 August 2021. However, the erstwhile state advocate was ill, and she had notified parties beforehand that the matter may not proceed, and a postponement for trial was arranged in the absence of the accused and the defense team, and the trial date then secured being 28 February 2022. On the said date, Advocate Caesar appeared on behalf of the state, and the case formally proceeded, or the trial proceeded, on 1 March 2022 for the week up to the 4th of March 2022, being for 4 days. From there, it was postponed to 5 September 2022 for the week. However, and this is not criticism at all, because the matter was dealt with very professionally, as the defense had indicated a prior commitment and could not honor the week of September. And in the absence of all parties, a date for further evidence was then arranged, being 30 January up to the 3rd of February 2023, and it proceeded for 5 consecutive days. 1 September 2023 was the following dates up to 14 September 2023. That was 4 days, and the state case was closed on the 14th of September, meaning it was a total of 13 court days that was spent on the state's case after hearing plus minus 19 state witnesses and 3 applications brought by the defense in that period. I would say 2 because the 174 I'll deal with now. As from the 14th of September, the matter was postponed to the 20th of September 2023, whereby a Section 174 application was brought by the defense, and the ruling by court on the 19th of October 2023 was then ruled in terms of Section 174, and that ended the state matter, the 3 applications, and it lasted a total of 15 court days. During the week of 18 June 2024 to 20 June 2024, after 3 consecutive days, the defense case was closed, and on 1 November 2024, the date was secured, including the date of 9 December 2024, was set aside for address on merits. However, due to myself having sustained an injury, I indicated to the state and the defense that there's a possibility that I may not be present on the 1st of November, which I happen to be, and they had elected, correctly so, the safest option was to proceed on the 9th of December 2024 for address on merits. Indeed, then it had proceeded on the 9th of December 2024, continued, where am I now? 24. Thereafter, 29, yes, the defense case was then closed. It continued 29 September 2025, 30 September 2025, and 1 October 2025 for the extremely long judgment delivered by this court. I still shudder. Thereafter, it was postponed to 23 January 2026 for the pre-sentence report, which was then, the court heard the evidence of Ms. Jessie Thompson, and from that date postponed to yesterday, 15 April, and I will summarize the proceedings that took place yesterday, and then hence we find ourselves here today, 16 April 2026. In total, I think what felt like an extremely long time and which has been discussed as 7.5 years, it's clear having to combine 6-7 defense counsel, state, court was available, nonetheless was quite a task, and it amounted to the matter proceeding plus minus twice a year on 4.5 days per session. So the trial lasted, I would say, plus minus 31 days. Okay. see where I stopped. The court has decided to, in this instance, instead of starting by placing on record the provisions or principles traditionally taken into account by any sentencing court, to deal with the mitigating heads of argument placed on record by the defense, thereafter with the address by the state, and then the court will proceed in calmness with the principles applicable before sentence. Okay. First then, with regards to the heads of the defense, and the same will apply to the state, the court does not deem it necessary to repeat what has been placed before court. The defense had submitted detailed written heads of argument in advance and then addressed the court yesterday, being the 15th of April 2026. Therefore, the court has indeed had sufficient time prior to yesterday to read, peruse, and after yesterday's arguments to digest what has been presented to court by the defense. I will start off by, it goes without saying that in this instance, the defense had requested that or stated that there is no other sentence which is appropriate save for a non-custodial sentence, and I will continue with that at a later stage. Therefore, the court has had the opportunity to visit and peruse all the case law as quoted in great detail by the defense and has given it the full attention that it deserves. The case law is attached, although in 3 pages, to the heads of argument filed by the defense. It will be a moot exercise to repeat all the cases listed, unless you would require me to do so. The same may be said regarding the pre-sentence report. It was submitted to court on the 23rd of January 2026, and Ms. Thompson had read the report into the record verbatim. Therefore, there is no need to repeat the contents, as it is reflected and recorded and forms part of the written transcription and record of this court. The court therefore has had more than sufficient time to peruse and to take note of the contents of the said report, and combined with the evidence in chief, the cross-examination that followed, including the re-examination and clarity questions by court, it is clear that the pre-sentence report has been noted fully, and I will deal with the recommendations shortly. The contents are noted and accepted, therefore, as evidence on behalf of the accused person. The court will, however, refer to a few points that may require a response from court at a later stage. The court has indeed scrutinized the case law quoted by the defense in paragraphs 25, 26, and 27, and the court reiterates the importance of the findings made regarding the role of the courts in upholding the Constitution, wherein the state is described as the role model for our society. This court is in total agreement with the submissions that let me just open this file. This court is therefore in total agreement with the submissions by the defense that a court's impartiality must never be open to reasonable doubt. For its moral authority, without it, would cease to enjoy legitimate public confidence and ready compliance with its decisions by all, and that our courts are to defend and uphold the Constitution and the rights entrenched therein. more so when the deprivation of an individual's liberty or freedom may be affected. It is indeed a core right to be enjoyed by all. Paragraphs 28, 29, 30, 31 and 32 sets out all the examples of sentences imposed by our courts as stipulated in the heads of arguments. There is no need to repeat the paragraphs, it was read into the record. What is clear is that there are a variety of sentences imposed by our courts regarding the possession of firearms over the years, pertaining to semi-automatic rifles, pistols, revolvers, including offences that were committed using firearms. What is to be distinguished in these matters are notably, as raised by the defence and as per the pre-sentence report and viva voce evidence of Ms. Thompson, the circumstances under which the offences were committed, including the purpose thereof, the duration, and as highlighted by the defence, the issue whether any harm or injuries emanated from the offences. Further, that the ammunition was fired had been described as celebratory shots, and that there is no case law pertaining to the facts relating to the matter before court, more so based on the term used being, and I quote, celebratory shots. A further submission by the defence on record mentions that should any court consider a custodial sentence as appropriate in the matter before the court, it will be seen as the accused is singled out for unduly harsh punishment. The defence concedes the offences are serious and that the case law differs as the defence had pointed out in the case law on record, and surely again emphasised that the duration, circumstances, including the lack of harm to person or property, should be considered, that indeed it is the accused's right not to show any remorse. It has no impact on sentence. Further, that the accused regrets the perception that his actions created. When dealing with a pre-sentence report, it may appear as if it is a repetition on the side of the court, but I need to mention, because the points raised by Ms. Thompson indeed overlaps with the heads of the defence drafted on behalf of the accused. In addition to the heads, I will add the following: that the accused person's personality type was assessed, and the reason for doing so was to offer context to his conduct and potential behaviour expectations. Ms. Thompson had regard to the personal circumstances of the accused, his background, education and career. Further, that the accused continues to assert his innocence. Nevertheless, however, he regrets the incident. The report deals with the evaluation of actual and potential harm because of the offences, the seriousness of the offences, as well as, once again, the purpose of the offences. And in recommendations, Ms. Thompson proposed that a monetary fine as a sentence option should be applicable, and describes the fine as a sentence option which will reflect the gravity of the offence. Further suggestions by Ms. Thompson were to restrict the accused person from obtaining a firearm license for a specified period, and that he should be ordered to make a financial contribution to Gun Free South Africa, an NGO focusing on reducing gun violence in South Africa. She also testified, and it is contained in the said report, that the firing of the celebratory shots had been deliberately planned as a distinctive element of the event, reflecting the established tradition of incorporating unique features into each celebration. She continues to state that the planning does not suggest that the activity was undertaken with the intent to commit an offence or endanger lives or cause damage to property. And as mentioned in paragraph 17.3 of the defence heads of argument now, that the careless and reckless discharge of firearms in a public setting conveys an inappropriate message about gun safety and responsible firearm use. Now, in this instance, it was mentioned that particularly when a prominent leader exhibits such conduct. The court agrees with this submission. Further, the court agrees with the submission by the defense that the actions of individuals in positions of influence are likely to be emulated by their supporters, thereby warranting what is perceived to be more severe assessment of their behavior. However, the defense then proceeded to state that the behavior of the accused indeed once again reiterated did not cause harm to person, property, and the court was then requested to consider that the said firearm in question was returned to the lawful custodian promptly, and that the celebratory shots were fired in a very short space of time, and that the accused had not loaded the ammunition personally. Further, that the accused had obtained the firearm from an individual most likely affiliated with tactical security services. On this aspect, and on certain aspects raised by counsel yesterday, it's clear this aspect was dealt with in judgment. It refers to the merits, and when we deal with leave to appeal application, it is when the court will hear the merits. The court's finding in judgment is clearly stipulated regarding how possession, there was no finding as to how possession was gained. That is as far as I'm going to say. The rest we'll do during leave to appeal. And some of the controversial statements during, how will I say, reply by replying counsel. That in essence were the points raised by the defense and the social worker, Ms. Thompson. And as I've stated yesterday, reading the paper gives new meaning when one hears the oral arguments in court. It gives more perspective, insight, to see and hear the tone of how a statement is made has a different impact on a court as a piece of paper which is words. So therefore it was important for the court yesterday to pause when it did and then retire to indeed consider sentence. Those were the aspects as stated, dealt with by the defense, and I will now deal with the aggravating circumstances as indicated or raised by Advocate Caesar on behalf of the state. The state submitted that they request that the court should consider a custodial sentence in this matter for the following reasons: that the incident was planned and it was deliberate and executed with precision, and that the submission is made based on the accused's own evidence. Also on this aspect, I would say we will deal with the merits once we reach that point. Further, that it was a collective decision made by the EFF's leadership and that it was planned to entertain the crowd to ensure that the crowd is not bored during the event. In this regard, the state relies on the submissions based on the evidence of the accused that, I quote, everything was perfect and calculated and designed to be the way it was done, unquote. Therefore, it was not an act based on a lapse of judgment. These submissions was then substantiated based on the case law by the defense and similarly quoted then by the state. The state and the defense basically, in fact, relied on the same case law pertaining to this matter. The state continued to submit that on the ballistic evidence presented, it was established that to discharge a semi-automatic rifle in a built-up area densely populated using a .223 Remington round was fired, and that retains lethal kinetic energy on descent. The potential for mass injury or harm was real, it was foreseeable, and scientifically established. Mtansane is a residential area. The state alluded to the fact that the accused's position as a public leader and role model is, I would say, a fact. Submissions made thereafter by the state requested the court to consider that the accused is a member of parliament and also the president of a political party, admired and followed by millions of South African citizens, and arguing that it is aggravating and not mitigating as per the defense submissions in this regard. The state referred to the video footage which was accepted by court. That again, I will say, deals with the merits. It was clear what footage was admitted by court and what was not admitted. The state alleged that the accused clearly lacked insight and accountability and sought political justification as an excuse, thereby undermining the public confidence in the administration of justice. These submissions was followed by the concerns the state raised regarding the evidence and pre-sentence report drafted by Ms. Thompson and the findings by the witness and the submissions by the defense regarding the brevity of the possession and that it was not accidental, and that the discharge of a semi-automatic rifle cannot be described as benign, and since the risk of injury or harm is extreme. Celebratory purposes in this regard, the state submitted that this type of discharge may not be condoned, and that the law makes no provision for such actions. The state then embarked on the discussion and submissions regarding the case law, which was placed on record. I am not going to repeat, it has been noted. The only difference I may add by the side is that although the state and the defense relied on the same case law, it is clear that the state will use the portions which is beneficial to them, and the defense would obviously use the portions which is beneficial to the defense. And ultimately, at the end, the court is required to bring them together. The fact that the state further continued that the fact that there appears to be no harm or injury caused as a result of the commission of the offense is conceded by the state, however disagrees with the defense regarding the weight that it should be attached by court. The parliament criminalized the creation of risk, not that there is a requirement of an actual harm or injury, but the actual act itself. The state continued to highlight three, which they termed, I'll say, pointers, that being the imperative of equality before the law. I'm not going to elaborate on that point at this stage. The imperative of proportionality and the imperative of deterrence. Those were the three highlighted by the state. And concluded its submissions by referring to State v. Zinn and pressing I'm trying to also expedite the sentence. Just a minute. The state then submitted that the proposed sentences will give proper effect to all the principles and objectives set out in State v. Zinn, with safety and it will satisfy the constitutional mandate of equal treatment before the law, and it will serve the legitimate and pressing interests of a society that has the right to expect its leaders to obey the same laws they are elected to uphold. Now, the court will proceed with the principles traditionally taken into account by sentencing court. It is a well-known fact that sentence proceedings are the most difficult part of any court proceedings. It does not only affect the accused person, but also the family of the offender, including the society, that being the public welfare, safety, concern, and the interest of society. It is also known that a court is obliged to consider the normal aspects of sentence traditionally taken into account before imposing sentence. These aspects being the accused is indeed a first offender before court and has no outstanding or pending criminal matters. It also includes the possibility of reoffending. I'm not going to elaborate on that aspect. It was done by the defense. It is noted as one of the principles to be taken into account. It also includes loss of employment. In this instance, the case law is clear that should sentence result in the loss of employment, it should be noted that crime is an inevitable consequence of crime, or loss of employment is an inevitable consequence of crime. The court is also obliged to consider the family of the offender. This fact was fully discussed in the pre-sentence report submitted by Ms. Thompson, who testified in mitigation of sentence. On this score, I also think it is appropriate to highlight, I do not intend to discuss the depth of the pre-sentence report, as was submitted by the defense in the heads yesterday, orally, that I accept it was an invasion of the accused's personal space. It could never be seen as an easy exercise. And we heard that evidence of Ms. Thompson, I think, in excess of 5 hours on the 23rd of January. And I think that in itself was surely not a pleasant experience. So I'm merely going to highlight how I have highlighted the content and then the family, etc. I do not intend to rehash personal circumstances which has been dealt with or heard. The other aspect that the court needs to consider is the state of health of the offender, and the court was informed that the accused does not suffer of any medical or physical ailments as per the report. Youthfulness, it is so that the accused is still relatively young. And most importantly, the position of trust. This is one pointer that the court will return to. It requires full reasoning by court, and I will do so during the process of sentencing. The further aspect is that the prevalence and seriousness of the offense. This is an aspect the court cannot shy away from today, but also requires full reasoning, and the court will do so during the proceeding of the sentence. Those two aspects. The above are but a few pointers traditionally taken into account by courts before sentence, and some require a detailed explanation by courts. It is well known that the ends of justice are four in number, being deterring, preventative, reformative, and retributive in its nature. It, however, consists of 5 important functions. It should act as a general deterrent. It should also act as a specific deterrent. It should also, or it must enable the possibility of correction. And it must be protective of society. And it must further also serve society's desire that crime be adequately addressed by courts. It is in the public interest that punishment be meted out fairly and without the measure of excessiveness that would mark it as being merciless and unacceptably unfair. The court is mindful that neither the call for true punishment and revenge, neither the cry for understanding must be given undue weight. The ends of justice, as mentioned already, must be given due regard when determining sentence. And it is required that a court should strive to accomplish and arrive at a judicious counterbalance between the elements mentioned and ensure that one element is not unduly accentuated at the expense or exclusion of any other element. It has been often stated in various case law that the sentence imposed should fit the offender as well as the crime. It must be fair to society and blended with a measure of mercy according to the circumstances of each matter. True mercy, therefore, has nothing in common with soft weakness or maudlin sympathy with the offender, since it is a crucial element of our justice system in its own right. It is also not an element that mere lip service is paid to, but indeed a sound factor that each court must consider and which must clearly reflect in the sentence imposed. However, courts are required not to strive, as stated, for severity, but neither, on the other hand, surrender to misplaced pity, and should not flinch from firmness where it is called for, and that a court should be strict enough to ensure that the objects of punishment are adequately furthered, and indicating thereby that crime will be effectively punished. Having said that, this court is well aware that a court should approach its task with a humane understanding of human behavior and frailties. Just a minute. I've been talking a lot, just a minute. I think at this stage, while we are still proceeding calmly, I'm going to deal with general concerns when reaching sentence regarding matters of this nature. Thereafter, the court will deal with the or reply to the offense before court or the matter before court. It should be noted that crime is inconsistent with the rule of law and the fundamental value of our Constitution. It undermines the constitutional commitment to human dignity and further the achievement of equality, including the advancement of human rights and freedom. Crime is therefore the antithesis of an open, accountable, democratic government as required by our Constitution. Chaskelson P. in South African Association of Personal Injury Lawyers versus Heath and others, 2001, SA 1883, Constitutional Court, 2001, in brackets 1, states that, I quote, Elected office bearers and officials in the public service have become one of the most serious threats to our country's well-being, and that is to state the obvious. Although the mentioned case deals with corruption and crimes of dishonesty, it is still relevant to crime in general, and as far as it relates to public office bearers, as the impact and consequence pertaining to the matter before court today remains the same, if not worse. It is clear that if crimes are allowed to go unchecked and unpunished, it poses a serious threat to our democratic state. Crime in South Africa is ever escalating, and it appears to be an acceptable way of life in our country, this being a situation the courts cannot allow or tolerate. The incidents may well be characterized as a pandemic that needs to be recognized as such and requires concerted and drastic efforts to combat it. It is regrettable that too often in South African courts, the so-called, and I quote, non-violent crimes have been visited with lenient sentences due to the classification of no violence, and that perpetrators of these offenses are seen as not to be truly criminals or even prison material due to their ostensibly respectable careers and lifestyles. The above-mentioned case stated on record speaks about dishonesty. However, this court will dare to say that it does not merely refer to related offenses such as fraud, etc., but it includes the dishonest character of an individual, indicating that such conduct entails gross breaches of trust. At the beginning of the sentence, the court mentioned the element of trust and that a court should consider before imposing a sentence, and based on the facts of the matter before court, including the circumstances in which the offenses were committed, it shouts of the breach of trust and is of great concern to this court today. The accused is in a position of trust and elected as such by the members of society. The conduct of the accused and the effect of his actions and the impact of the conviction on the accused combined all reflects, contrary to what is expected from our Constitution, the complete absence of accountability and breach of trust by the accused person before court. Going to try and summarize the response to the defense submissions as follows. It must be noted, and the accused confirmed, that the event was planned. Emphasis on the word event was planned. And that it was a unique established tradition planning an event. Firstly, I stand corrected on this aspect, but what I should have clarified is the following, that this was, according to the knowledge of this court, the fifth birthday celebration was the first of its kind. I do not understand the wording of it was a well-established tradition. We heard that the 10th birthday celebration, what the main feature was, but whether it was an established tradition at the 5th birthday celebration, I'm not aware. As a result, it is a great concern to this court that an event was planned and that what appears to be the unique feature of the event ended up in the commission of an offense or offenses. Surely this can never ring true. As per the submissions, the court is asked to consider that the accused had planned the event, and then it goes a step further, because contrary to the view of the defense and the view of the state, today it is clear that the planning included that the accused will possess or take possession of a semi-automatic rifle, fire a .223 Remington bullet into the air, thereby causing possible harm to person or property in a built-up area. That it is now called a celebratory shots, that is sugarcoating. Nothing more, nothing less. The facts found by court during its judgment, and this is not merits, these are facts. I'm going from memory. It was the evidence considered was that the accused had decided that the event was planned by the leadership. All decisions were made by the leadership. So there can be no doubt that you are saying the unique feature of the event was committing 5 offenses. That is the bottom line. Clearly, planning of this nature is in contrast with the law. How can a court of law consider that the actions of the accused did not intend or did not entail the intention to commit an offense? It is not it is not the thinking of the court, it is the facts before court, because that is what happened. It wasn't, as the state correctly stated, an impulsive act. It wasn't, as a result of the case law we heard, an act of passion. It wasn't anger. It was the event of the evening. And therein lies the difference. It should take considerable planning for an event of that magnitude, and I'm deviating from my written judgment, of that magnitude, that as to how, when, and exactly at what time you will take possession of the firearm, where you will fire it from, at which point we all know then, Mr. Snyman, you returned the firearm to Mr. Snyman. That finding was made by court. The court did not find it was handed to you by Mr. Snyman. That is what I'll say in that regard. So that to reason any otherwise is nonsensical. This is a decision that a person made to possess a semi-automatic rifle unlawfully, and including the decision then to proceed and fire the said rifle in a built-up area in a crowded stadium. The decision to break the law has been made, and it was made with the approval of the accused person and the leadership. Since it's confirmed that this was the future planned for the event, it clearly indicates that the accused had known it was unlawful, He knew that it may cause harm to persons or property. He knew all the above, and it yet proceeded to possess the rifle and to fire the shot in celebration of the 5th birthday celebrations of the economic freedom fighters. Always knowing when this was being planned, arranging this special feature that it is in contravention of the law. And that this decision was made long before the actual event. Such acts can never be condoned by this court in any instance. The court cannot dismiss these actions planned by the accused as mere celebratory shots, and further justify the commission of crime under the pretense that it was celebratory shots. Much has been said yesterday regarding other offenders who've committed acts of this nature, worse, who have has not been brought before a court of law. This court is not in a position to answer for those matters. Safe to say, I trust that surely the long arm of the law would reach and bring those offenders or suspected offenders before court. This court can only reply and answer for the matter before it, not for what has been said was done by Mr. A to Z or Miss A to Z. I'm unable to do so. My focus is on this matter solely. With regards to yes, as I say, as far as it pertains to individuals who had committed the same offences and had not yet been brought before a court of law, should this type of reasoning be condoned, it is clearly not conducive to the interest of society, and the courts are required to act accordingly. And that is as much as I can say regarding the offenders who are still to be brought before courts. The other aspect that is aggravating in this matter and which needs to be mentioned is the astronomical financial impact this matter has had on the taxpayers' pockets or at the taxpayers' expenses. By saying that, please, that is not laid at the foot of the accused person solely, not at all. It was your right to take this matter on trial. I'm saying merely that a trial of this magnitude involved tremendous human or manpower. If we look at the ballistic side of this matter alone, the transport of firearms from KZN to Quebeca and back, the ballistic unit resources and equipment, preparation, SAPs. The tragedy is that this matter has also led to so many people that did not have access to this court on several days where this matter proceeded. Mothers could not approach the court for maintenance. They could not reach inside. Grandmothers could not come to the offices to apply for foster care or guardians, appointment, adoptions, domestic violence. Those people did not have access. And that is tragic. These are members of the community this court services on a daily basis. They wake up, as you very well know, all of us very well know, by 3 a.m., by 4 p.m., those little kids are dressed, washed, and they walk to court. And yet they cannot reach the entrance of this court for the help that they need. What has transpired is indeed sad. It's a sad day for justice if this is what bringing a matter of this nature to court results in the impact on the interest of society. And as I've stated, the courts must protect the interest of society. Not only did it affect those people I've mentioned, courts adjourned early. Our court rolls are overcrowded beyond comprehension. Inmates had to be returned to correctional services, leading to the extension of the overcrowding of prisons or correctional facilities. Witnesses who traveled from far, who lost a family member, let us say in a murder incident, they did not get closure on a specific day which was allocated to them for their matter to be heard. They have to come back. So yes, this matter indeed is sad because it has an immense tragic effect on the administration of justice and the very interest of society that is to be served by justice and its staff and courts. And that is not overemphasizing, that is a fact and a reality. The only aspect I'll mention with regards to the time frame of the actual possession of the rifle, yes, indeed, I agree it was very short. I agree with the submissions of the defense that yes, the charge sheet mentions 1.223 Remington cartridge, correct. I agree that the charge sheet mentions 1 SPA 249. Therefore, the court is limited to what you have been charged for, and that is what I'm dealing with. Nothing more. Safe to say then, on what the court has already alluded to, the commission of these offences are not insignificant, and the impact thereof remains the same, whether it was done in less than a minute. The impact remains the same. Now, this is a difficult matter to raise because it was alluded by the defense that should a custodial sentence be imposed by court, it will show that the accused is singled out to endure a harsh sentence. To this, the only reply from court is, it is not the court who has singled out the accused person. He had done so all by himself, not the court. In the light of the position that he holds as the CIC of a political party with massive support, it's not the court who had singled out the accused person. The fact remains there is a significant amount of accountability on the accused, and on this regard I'll add the following, that please remember, it is not a political party who has been convicted here. It is not the economic freedom fighters that have been convicted. It is a person, an individual, who so happens to be the CIC of a political party. Nothing more, nothing less. It's not the party. It's an individual, and that is how it is perceived. And while I'm on the topic which is uncomfortable for everyone, let us continue with this political trend that is followed. This court heard, as I've stated, plus minus 19 witnesses. Not a single witness testified before this court testified regarding any political facts, or that is not facts before court. The evidence or political agenda was raised by the accused, which is your right, but those are not facts as part of the state's case. And that's where it ends. A court of law and politics do not blend. The two do not collide. Judiciary stays in its lane. Politicians stays in their lane. The easiest way to explain this is, I think the minds of a jurist and the minds of a politician do not function on the same frequency at all. Hence, the court is expected to remain independent, dispense with justice without fear, favor, or prejudice, and that is the duty of this court. The rest is of no interest, only the law. Just a minute. On this topic, I'll end off by saying, at all times, the judiciary, including the justice system, will never be intimidated by any politically charged utterances or parties. There is no room in a court of law dealing with a criminal offense for the court to enter into politics at all. Just need to find my rhythm as well here. Right. What is apparent then is that people of this country are speaking as one. Crime is reaching astronomical proportions, and the courts are required to do all in its power to combat the situation and to ensure that all would-be offenders or offenders who are still to be brought before justice faces the full arm of justice. And surely if this is not done or goes unchecked, as I've stated, it will result in the perception that crime is an inevitable consequence of life in South Africa. It must further be noted, as much as the rights of the accused has been emphasized, and correctly so, as it is enshrined in our Constitution, members of society too enjoy rights, the same rights as enshrined in our Constitution. These rights are not one-sided and enjoyed by all. I'm about to end off. I just want to briefly refer to our engagement yesterday in the oral submissions by the state and the defense regarding the two case laws submitted, one by the defense and the other by Advocate Caesar. Just want to get to the relevant part. Yes. Okay. Gracious. The matter submitted by the state being Romeo Janssen and the state, case number CANR 220/18, delivered by D. Van Sale, then DJP, and by the defense, that of the Malundana case, case number CC20/2024, delivered by Brooks J. Now, in this instance, it was interesting to read both. And what is abundantly clear is that in the matter presented, the Malundana case, the facts are completely opposite as the ones we are dealing with today. In the matter submitted, the Malundana matter, was a gentleman of 62 years old who had, after a very long period of time, secured employment as a security officer protecting a school, which led to him firing a handmade firearm. The difference in that matter, which the judges considered as sentence and mitigation of sentence, is the accused there had pleaded guilty. He had also spent a period of time incarcerated, 4 months in custody before. Further, he was also a first offender. He had assisted the victims at the scene, and he himself had called the police to come and assist. He had also contributed to the costs of the family who suffered in the incident. That is the set of facts unique to that matter. Now, what is interesting in the Janssen matter, counsel argued yesterday that the matter cannot be of assistance to the court. I disagree on that aspect. Indeed, it was, because I think it was said that he had previous convictions, Janssen. But when you read the actual judgment, the judge states clearly that the accused was treated as a first offender despite having previous convictions. So that is not relevant. That was, he said, and he was found to be, or having been in possession only. There wasn't a crime that was committed on the day he was arrested with the firearm. And then interestingly, after being asked by the defense that all people be treated equal, it was submitted that Janssen is a gangster, therefore a member of Fat Boys, and therefore sentence of custodial sentence is in order. I failed to see the reasoning and the rationale behind that, but what is evident and clear after discussion of all the cases submitted by the state and the defense, in the view of this court, each case is unique. Every person is equal in law. What does equal mean in my view? That the court should ensure that accused rights to a fair trial is protected and that it applies equally to every individual who appears before a court of law. Sentences, we have this contradiction and variety because, as I've stated, each set of circumstances and facts are unique. If we take, without disrespecting a gangster, we cannot say for gangsters, right, there's a sentence of 5 years. For politicians, it should be 6 years. For the homeless person, it's 10 years. No. It's done in its totality. And unfortunately, the accountability on a public office bearer is a lot more. It weighs heavy than that of the regular South African person. So by saying that, that doesn't mean you are not treated equally or the accused is not treated equally. That is not what equality, in my view, entails. I'll end it shortly. There we go. Just a minute. I'm nearly done. Just a minute, please.
Worship, if I may, this is, I'm so sorry about this. I need an urgent comfort break, Your Worship. I've been sitting here since 7:30 this morning. So sorry about that.
I'm going to single you out, Advocate Caesar.
I tried my best.
So I was perusing the file to end off, but okay, can we then say, I'm sorry for this then, but instead of 5 minutes, it's a large crowd. Shall we say this is then the tea adjournment, we come back, we continue then thereafter? I'm sorry for this. No, Advocate Nklatobishan, I cannot, just now we all drown when that man cannot cope. Okay. Please, I'm going to, just a minute. Sorry, feel free to... I'm going to leave this here. To come back and continue? Yeah. be seated. Okay. We are back on record then for resumption of RC 446 of 2020, and I will proceed where we left off. Just a minute. All right. I will then proceed and in summary just add the following before pronouncing the sentence, is that we should also keep in mind the magnitude of the offense that the accused has been convicted of. We've heard daily or weekly of children playing in their front yards in the street who are caught in crossfire, random shots fired, killing people. It's just the first time that we hear it's being called celebratory shots. And in essence, the accused, all as stated, are equal before law. But in your instance, it cannot be said that you are not accountable due to the position you find yourself in. You are accountable to members or citizens of this country, to your followers, to the youth. And that accountability stems from your position. And that is where I'm going to end this. You may please stand up. Not the court only. Sorry. Maybe I should be clear. Okay. Sorry for that. All right. After careful consideration, and I can show you I have done so, free of any interference, this judgment or sentence is the sentence of this court and this court alone. In respect of count 1, you are sentenced to a period of 5 years imprisonment. In respect of count 2, you are sentenced to a period of 2 years imprisonment. In respect of count 3, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 4, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 5, you are sentenced to pay a fine of 20,000 rand or to undergo 6 months imprisonment. In terms of Section 280, subsection 2 of Act 51 of 1977, the court orders that the sentence imposed in respect of counts 2, 3, 4, and 5 run concurrent with the sentence imposed in respect of count 1. You may be seated. Thank you. May we, Advocate Otis, sorry not to interrupt you, may we just deal with the Section 103 inquiry and then we can proceed to that part? I assume you are ready for that part as soon as we've dealt with the 103 inquiry. Certainly. Okay. Let me just find my notes here. Just as a brief explanation unless it's not clear, the next step after sentence is that the court is obliged to deal with the provisions of Section 103, subsection 1 of Act 60 of 2000, meaning that the determination of unfitness, as I've explained in the beginning of the sentence, should not be made separately before sentencing, as information relevant to such fitness may emerge during the process of mitigation or circumstances, and the inquiry in terms of Section 103.1 Act 60 of 2000, since in terms of Section 1, the accused is deemed unfit to possess a firearm or license in future by virtue of having been convicted of a crime specified in Section 103, subsection 1 of Act 60 of 2000, and reasons may therefore be advanced or evidence presented to enable the court to consider the possibility of determining otherwise. So, Advocate Houders? No submissions. Thank you. Advocate Caesar, on behalf of the state. Due to the reasons provided by court during sentence and that we are dealing with unlawful possession, due to the virtue of the nature of the offences, the court therefore makes no otherwise order and you remain to be deemed unfit, and it is followed by the following further order by court, that Section 103, subsection 1, read with the provisions of Section 104 of Act 60 of 2000, the accused then remains to be deemed unfit, and the effect of the declaration of unfitness is as follows. All competency certificates, licenses, authorization and permit issued in terms of this Act to any person who becomes or is declared unfit to possess a firearm in terms of Section 102 and 103 cease to be valid from the date of the conviction or the declaration, as the case may be. B, despite the noting of an appeal against the decision of a court or the registrar, the status of unfitness contemplated in paragraph A remains in effect pending the finalization of the appeal. Further, a person who becomes or is declared unfit to possess a firearm in terms of Section 102 or 102.3 of Act 60 of 2000 must within 24 hours surrender to the nearest police station all competency certificates, licenses, authorizations and permits issued to him or her in terms of this Act, all firearms in his or her possession and all ammunition in his or her possession. Therefore, it should be noted that subject to the provisions of subsection 9, subsection 3, subsection B, and after a period of 5 years calculated from the date of the decision leading to the status of unfitness to possess a firearm, the person who became or becomes or deemed and declared unfit to possess a firearm may apply for a new competency certificate, license, authorization or permit in accordance with the provisions of this Act, being Act 60 of 2000, the Firearms Control Act. All right. So what we are left with is the application. Are you ready to proceed now? Okay. Let me just get that part of it ready. I'll be with you now.
What we left with is an application for leave to appeal against conviction and sentence, and an application for bail pending the outcome of the proposed appeal.
Yes.
The leave is not wanting bail pending the outcome of the petition.
Just a minute, Advocate Houders. I just want to quickly grab the notepad. I haven't drafted that, so I'll have to listen to you carefully here. Just a minute. Okay. Thank you. I'm ready.
51 provides that immediately follow this, provided with the full grounds.
An application for leave to appeal to the High Court of South Africa East Cape Division held at Grahamstown against the whole of the judgment convicting the accused of firstly unlawful possession of a firearm in contravention of Section 3 of the Firearms Control Act 60 of 2000, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state without holding a license, permit or authorization. The second count, Your Worship, that we seek leave to appeal against is unlawful possession of ammunition in contravention of Section 90 of the
Firearms Control Act 60 of 2000, to wit a .223 Remington bullet without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export or transit license, or other authorization to do so. The third count, Your Worship, is unlawful discharge of a firearm in a built-up area or any other place in contravention of Section 120 sub 7 of the Firearms Control Act 60 of 2000, to wit the CISA Prakashi Stadium in Lansane. The fourth count, Your Worship, is unlawful failure to take reasonable precautions to avoid danger to personal property in contravention of Section 120 sub 3
sub C of the Firearms Control Act 60 of 2000, in that the accused of control of a loaded firearm, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public, attending the 5th Economic Freedom Fighters celebration. And finally, the fifth count, Your Worship, is reckless endangerment to a person or property in contravention of Section 120 sub 3 sub B of the Firearms Control Act 60 of 2000, in that the accused unlawfully discharged or otherwise handled the firearm, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the Economic Freedom Fighters celebration, residents of Mdansani and the employees of Gear House, with reckless disregard for the safety or property of the general public attending the 5th Economic Freedom Fighters celebration, the residents of Mdansani and Gear House employees. Your Worship, this application for leave to appeal is based upon the following grounds of fact and law. Firstly, this is in relation to the convictions, Your Worship. In assessing the evidence, having acknowledged that the court was obliged to evaluate circumstantial evidence in this matter, the court had regarded to the often quoted dictum in Rex v. Blom and held that there are two cardinal rules of logic which cannot be ignored. And there's a quote from Your Worship. There are firstly that the inferences sought to be drawn must be consistent with all the proved facts, and secondly the proved facts should be such, and Your Worship said, I quote, that they exclude every reasonable inference from them save the one sought to be drawn. Yet, we say, Your Worship, that Your Worship, the magistrate, committed a material misdirection not having any alternatively sufficient regard to all of the facts that militated against the guilt of the appellant, of the accused at this stage, Your Worship. We say that this occurred despite, Your Worship, the magistrate having held, and there's a quote here, Your Worship, the court must not take each circumstance separately and give the accused the benefit of any reasonable doubt as the inference to be drawn to each one so taken. It must carefully weigh the cumulative effect of all of them together, and it is only after it that it has been done so that the accused is entitled to the benefit of any reasonable doubt which it may have as to whether the inference of guilt is the only inference which can be reasonably drawn. To put this matter in another way, the state must then, as stated, satisfy the court that each separate fact is, let me rephrase as stated, the state must satisfy the court not that each separate fact is inconsistent with the innocence of the accused, but the evidence as a whole is beyond reasonable doubt inconsistent with such evidence. Yet we submit that Your Worship committed a material misdirection not having any alternatively sufficient regard to all of the facts that militated against the guilt of the accused. In this regard, we say further that Your Worship further erred in holding that, and there's a quote, a number of circumstances, each individually very slight, may so tally with and confirm each other as to leave no room for doubt of the fact which they tend to establish, though each taken by itself, but as light as a feather, However, join them together, you'll find them pressing on an individual with the weight of a millstone. And we say that you further erred in this regard, Your Worship, when you held. It is further described that in cases surrounding circumstantial evidence and circumstantial evidence alone, evidence varies infinitely in its strength in proportion to the character, to the variety, to the independence one of another, and one might describe it as a network of facts cast around an accused person. That network may be that strong as it is in part, and it may also leave gaps and may then allow the accused person safe passage. It may be so close, so stringent, so coherent in its texture that no efforts on the part of the accused can break through. It may also come to nothing, and or on the other hand, it may be absolutely convincing. The law does not command that you should act upon certainties alone. We often ought to act upon just and reasonable convictions founded upon just and reasonable grounds. The law asks for no more and the law demands no less. I further refer to State v. Kwanda, 2013, 1 SSCR 137, Supreme Court of Appeal, where Maria J. stated that such an inference is only justified where the state has established facts from it can properly be inferred by a court. We say the court mentioned but only paid me a lip service to the issues raised in argument on the merits on behalf of the accused, did not have sufficient or due regard thereto. In this regard, the court mentioned the 23 statements by the investigating officer, Colonel Swartboy, the lack of DNA or fingerprints linking the accused to the firearm, no eyewitness complaint, and various other factors relating to a 9mm Glock firearm and ammunition. However, the court did not take these factors into account in its application of the two cardinal rules relating to the admission of circumstantial evidence. We go further, Your Worship. We say, additionally, the court's assessment of the circumstantial evidence and acceptance thereof did not have regard to the absence of any damage to any structure and the inability to link the suspected firearm and spent cartridge to the accused. Other significant factors in this regard were that no person reacted in fear, and the 5 VIP SAPS members had not witnessed any shooting.
I'm sorry, if you can just mark there where you are busy with. She's informing me that there's a sound coming that she needs to check from our court recording machine, and I just please don't want anything to go wrong with our recording of the stage of the proceeding. So she's asking that we just adjourn for her to check and that all cables, etc., are in place. I'll just leave, please. I'm not going to pack up everything, just leave it here, and then I'll be, when you're ready, they'll indicate to the police and I'll enter. Thank you. Court will adjourn. Wouldn't be nice to move. Thank you. It's not yet. Please be seated. Abongile. Sorry, Advocate Otis, she says it's not yet. She'll. Oh, you must go ahead. Okay, sorry. She said you'll go ahead and she'll indicate if it's now clear. Thank you.
The next point that I wish to make is the court summarized the facts in dispute and held that it all amounts to whether the firearm that was fired on the night in question was a real gun or a toy gun. This issue was not resolved beyond reasonable doubt by the evidence led in this matter. Consequently, the accused was incorrectly convicted of the charges. Then the court further erred in allowing the viral footage to be viewed without it having been authenticated. In this regard, the court took issue with the defense having relied on the footage during cross-examination of state witnesses and the presentation of the accused's case. The court subsequently held the facts which the court will rely on without giving any real regard to the viral footage and no further findings required regarding the said footage. So what we're saying is, Your Worship said it's real evidence, it was allowed, it was referred to, and eventually Your Worship said it's not inadmissible, it hadn't been proven. Then we say the court further erred in having regard to the state witnesses en masse and holding that they were credible, reliable, and truthful. And the court cannot find any bias, prejudice, or any motive in the evidence of any of the state witnesses to indicate otherwise. This was premised upon the court having been very impressed by Colonel Ngwadleka, who was described as being a brilliant witness and had left no stone unturned. He had dotted every T and dotted every R. He had not made any mistake as far as the custody chain or the handling of the exhibits or serial numbers contained. The court finds him and all the above then as stated credible, reliable, and truthful. The extent to which the court had been impressed by Colonel Ngwadleka was further evident from the finding that he meets the criteria, in fact he exceeds the required criteria in his thoroughness, and he can be, or he is mentioned by this court to be not only an expert witness but a super qualified expert witness. That is the conclusion regarding Colonel Ngwadleka. This evaluation was in turn projected by the court to the rest of the state witnesses, even though there was no factual basis to do so. This in itself indicates a material misdirection by the court in its approach to the evidence of the state witnesses and the assessment of their credibility. In contradistinction, the court held that the defense witnesses, including Mr. de Klerk, were defensive and at stages argumentative. This is further borne out by the comparative analysis by the court of the evidence of Mr. de Klerk as compared to Colonel Ngwadleka, which was found to fall short and only be noted as mediocre. This biased approach to the testimony of the defense witnesses is further illustrated by the approach adopted towards the accused. The fact that he had stated that Mr. Mavundla should have been charged was utilized to discredit him. Additionally, he was found to have evaded many questions that had warranted a reply. The court held that it became evident that the replies were entertaining, but however the pertinent questions asked remained unanswered. He was further criticized for relying upon the viral footage whereas nobody else was. Having held that the court had to establish whether the version presented by the defense was reasonably possibly true, regard was had to the statement in cross-examination that the firearm had been in Gauteng. In this regard, the court held, and I quote, "Now as to what happened and where it was kept, no explanation was provided. It begs the question, dealing with circumstantial evidence, that what does the firearm being booked out to Mr. Mavundla in effect equate to that specific firearm is booked out to him for whenever it is needed for him or by him. Since clearly it does not mean it needs to be on his body since he left it in Gauteng. In doing so, the court appears to have lost sight of the fact that this statement had been made by the co-accused's counsel in cross-examination. There was no basis to attribute it to the accused. These findings by the court indicate the application of a type of reverse onus upon the accused to prove his defense, whereas, as stated by the court, the accused version only had to be reasonably possibly true. Put differently, the application of the two cardinal rules by this honourable court had to exclude the accused version being reasonably possibly true. Let me say this misapplication of the onus is further evident from the court having, in its concluding remarks, confirmed the two cardinal rules that require the inference sought to be drawn to be consistent with all the proved facts and to exclusion of every reasonable inference from them save the one sought to be drawn. This could never be the case in the absence of any objective corroboration that one would have expected to be present at the scene. such as damage to property, injury to people, or at the very least an expression of fear by anybody from the many people that have been in attendance at the celebration. And finally, in relation to the conviction, Your Worship, what we say is at the very least, it cannot be said that now the court might find differently or have a different assessment of all the evidence led in this trial. Consequently, it is respectfully submitted that the accused is not only a reasonable but a good prospect of success on appeal, and this application for leave to appeal against the convictions ought to be granted. In relation to sentence, Your Worship, we submit the following. We say that the sentence imposed by this Honourable Court is startlingly inappropriate to the extent that it induces a sense of shock. We say further, due regard being had to the prevailing circumstance at the time of the commission of the offences, and more specifically that they all relate to the same event in a very limited period of time that did not exceed 1 minute, all of the counts ought to have been taken as one for the purpose of sentence. There is no need or basis to impose separate sentences in respect of each charge, as this court did. We say further, insufficient regard was had to the personal circumstances of the accused. Most significantly, he is a 45-year-old first offender who was 37 years old when his offences were committed. He has not been convicted of any other offences in the interim. Additionally, he is married, he has 3 children and a wife to support. He is in full-time employment. He is also involved in community projects and regarded as an asset to the community. There is no basis to contend that he is a danger to society, thus ought to be removed from society. In this regard, Your Worship, I wish to highlight that no regard is had to the fact that he's led a blameless life during the duration of this trial, and he hasn't committed any other offence, and this was not taken into account in the sentence that was imposed. Furthermore, when it came to his community project, Your Worship questioned the social worker who testified, Ms. Thompson, in relation to the soup kitchen under a question to clarify, and it went as follows, Your Worship, just to indicate the approach of Your Worship. It's at page 163 of the record. Your Worship says at line 16, okay, let me leave that. I have only 2 aspects left, no few in fact, because if I had it before the time, it may have been a different story. The other issue, not an issue, but if you can explain. I think we go in the circle of a radius of 5 kilometres on each side of the court building. We're going to find about 4, 5, 6 soup kitchens. So, and this soup kitchen is specifically to the area of Mr. Malema is coming from. Ms. Thompson says, correct, Your Worship. The court says, so that is, what value must the court attach to that? Because I read it is from donations. Ms. Thompson says, part of, yes. And through the facilitation of the involvement of the accused, Your Worship. So Your Worship says, so it will continue. She says, it will continue most likely, yes. The court says, okay, so there's nothing special about the soup kitchen. Ms. Thompson says, there is. Then Your Worship cuts her, and Your Worship says, except that he may want to be very thankful that people are being served a meal that is outstanding. Ms. Thompson says, yes, Your Worship, and it was mentioned as part of the consideration in terms of the risk of reoffence. So the point we're making, Your Worship, is Your Worship undermined, with respect, the role that the accused makes to society. Put quite differently, Your Worship, neither, to my knowledge, does Your Worship or anybody else in this court have the right to claim that they started or initiated a soup kitchen, but Your Worship belittled that approach by saying, there's so many of them, they don't need him, whereas it was he who initiated it. So I needed to make that point. Turning to a more detailed list of what Your Worship had dealt with today. At the outset, Your Worship foresaw an application for leave to appeal. When Your Worship said, as to the firearm received from TSS, I dealt with this in my judgment. It will be an aspect for leave to appeal in the merits. There's no such finality in my judgment. This will rest until the leave to appeal. So it's quite clear, with respect, Your Worship, that you envisage that there be an application for leave to appeal, and that, with respect, permeated your judgment on sentence. When it comes to aggravating circumstances, Your Worship, you said that Advocate Caesar had highlighted and submitted that a custodial sentence was a normal, or was the right sentence, because this was a deliberate and executed with precision. And once again, Your Worship said these merits will be dealt with when we reach that point. So what we submit, Your Worship, is it was always envisaged by Your Worship that there would be an application for leave to appeal, and that this sentence bears that out. Your Worship also dealt with the accused being in a position of trust. Now, when we refer to a position of trust, Your Worship, is ordinarily a person who's an employee who looks after money or an assets on behalf of somebody else. It doesn't cover the situation dealt with in this matter. And we've never ever argued that there's an absence of accountability and a breach of trust. But all of this, Your Worship, will come to the final quote that I'll address Your Worship on before I make my conclusion. And that's to the effect that Madam Justice is meant to be blind and deaf, Your Worship, and not have regard to the actual specifics of the person when sentencing in the manner that Your Worship did so here. Now, Your Worship also asked the following in your sentence. You said, the event was planned, the accused said so. I stand corrected on this aspect. It was the fifth celebration, first of its kind, and I was told that it is a well-established tradition. She said, Your Worship said, I'm unsure about this. Now, Your Worship could have clarified that. The evidence was there, but to do so in your sentence, you say is a misdirection. Your Worship went further to say it was planned, the whole event was planned and ended up in offences being committed. That can't be true. Now, with respect, we say it's a self-defeating argument, because if one says it was planned, then one must take into account that having been planned, there were no injuries, there was no damages, nothing untoward happened to anybody, and nobody expressed any fear. But that doesn't find any place in Your Worship's judgment on sentence with respect. And Your Worship then referred to the term of celebratory shots as an instance of sugarcoating, nothing more, nothing less. And we say in that regard, Your Worship erred, because it's Your Worship's finding as well. It was part of Your Worship's questioning of Ms. Thompson, that if it's my birthday, can I go down the street and start shooting? And she said no. You said, well, aren't those celebratory shots? So the court knew all along that it was dealing with the celebratory shots, and that was the instance that had been clarified throughout. It wasn't a case of being part of another offence like a murder or anything. And if one draws a distinction here, Your Worship, and this is where we say you erred as well, in relation to the case quoted by my learned friend in this division. Firstly, that predated the one that we referred to. So it was taken into account when the second one was a non-custodial sentence by Brooks. He had already had regard to that full bench decision and didn't feel bound by it. We say those circumstances are clearly distinguishable. The man was a member of a gang. He had been involved in shooting their previous convictions. There cannot, with respect, be any parallel drawn between that. He was in possession of an unlawful, unlicensed firearm, and somebody being handed a firearm and shooting a shot in the air, as is the conviction here. Your Worship also went into the merits of the matter when Your Worship said there should have been planning as to how, where, and what time you would take possession of the firearm, whereas there's no evidence to this effect with respect to Your Worship. Your Worship also said that such actions cannot be condoned by the court and used to justify shots as celebratory shots. Your Worship, when we're dealing with sentence, we're not asking for condemnation. We're actually asking the court to lend the sentence or the punishment. Of this matter being brought to court and not being brought to court. Now, with respect, Your Worship, the accused was asked on this. He was asked, who do you think is behind this? And he gave the version. He said, I believe Forum is behind this. That was his version. This has caused a lot of consternation in this court. Even Your Worship yesterday said to my member of my team, Mr. Ngayatobi, why are we bringing Forum into it? And all he said was, it's in their heads, I've got to. And then Your Worship left it. Once it had been said, it was the state that had raised it, but it was unfair to attack Mr. Ngayatobi in that regard. Your Worship, also in regard to the financial aspect of this case on the taxpayers' pockets, with respect, Your Worship, that's a material misdirection.
Could you imagine if we had to take everything into account in every trial? And with respect, it became something of a political speech to refer to the women who come here for maintenance, can't get access to the court, the children that can't get their grants. Well, why don't we blame them for the potholes and for the weather as well, Your Worship, because they're unrelated. The NPA, if anybody ought to have seen it, the right resource provider, here we sit with no aircon. Is that the accused fault as well, Your Worship, because the funds that were used for this trial weren't used for that. With respect, Your Worship, it's an improper approach to take, and we misdirect in that regard. It would seem that you are appealing more to the public and justifying the decision that you're going to make rather than using a legal basis to do so with respect to Your Worship. They're not relevant factors in relation to sentence. We cannot, on the one hand, as Your Worship did, and I've quoted you say it's your right, your constitutional right to plead not guilty. You can have a trial. Oh, but by the way, you took up all these resources, therefore I'm holding you liable. That, with respect, is not a balanced approach, Your Worship. And Your Worship, this attitude is further borne out by Your Worship then carrying on through the time frame and saying, well, therefore the court is limited to what you're charged for and nothing more. Now, with respect to that implies that Your Worship wants to punish him for much more. We heard yesterday about all the different shots. We heard yesterday about all the different shots. There was only one shot in the charge sheet, one bullet in the charge sheet. There was only one ammunition. There was only one firearm. So it seems that Your Worship has misdirected Your Worship self in relation to the magnitude of what occurred that day. And it would be premised with respect then on the video that Your Worship allowed and then disallowed at the end. So we say that that's an incorrect approach to the entire trial, and more specifically the sentencing procedure, Your Worship. And then Your Worship dealt with the politics and that it's not a political party that has been convicted here. It's a particular accused. But there's no need, Your Worship. If you say I'm holding you liable as the leader of the EFF, there's no need to say I'm convicting or I'm not convicting our party. It's self-explanatory. Then Your Worship turned to what Your Worship referred to as an uncomfortable topic and said that Your Worship had heard all the witnesses and Your Worship said that politics and law don't mix. They must stay in their respective lanes. Now, Your Worship, while saying that with respect, Your Worship, and in your attempt to distance yourself from that's exactly what you, with respect, made yourself guilty of. Because your reference to the public out there, to all the people that have suffered on account of this, was more of a political speech than a judgment on sentence with respect, Your Worship. And this, Your Worship, was also what was displayed yesterday, as I explained, in the confrontation between Mr. Ndai Toby and yourself relating to AfriForum, when it was the state who had said it referred to AfriForum. And Your Worship, another aspect that was highlighted and doesn't find any meaning is there was a debate yesterday, and even my learned friend wanted to continue further on the return of the firearm and what the correct procedure is. Your Worship, there can be no doubt, and Your Worship knows that Section 34, the court must make an order returning. The state can't decide halfway through a trial or at any juncture to return the firearm, and that ought also to have been part of Your Worship's judgment, that the rifle may be returned to its lawful owner. Your Worship identified the lawful owner in your sentence as Mr. Snyman, but Your Worship didn't go further and say, and he's now entitled to the return of his firearm because it wasn't handed by him, but it was given back to him after the event. But that wasn't taken into account. So a more benevolent approach would have taken those aspects into account. Now, the most distinguishing feature, Your Worship, between this Ngala Nzima case of Malundana, Your Worship, was there were victims. There was a dead child of 13 years old. There was an injured child of 13 years old. Here you have none, with respect. There the judge in a higher court still found the compassion to deal with the bereavement and the loss of life and the injuries and still not impose a period of imprisonment on a person that had shot people, which is distinguishable on those facts, but it's far worse. And the simple fact remains, Your Worship, that to this day, the challenge was put out to my learned friend and to Your Worship to find any case dealing with what you call sugar-coated celebratory shots, we call celebratory shots, where anybody had been charged for it. And Your Worship says that's not a relevant factor. We say it is, with respect.
if one can have regard to how many soup kitchens are in the neighborhood, one can have regard to how many times this actually happens in real life. And Your Worship, having berated the accused for taking so much of the court's facilities and time, then turned around at the end of it and said, each case is unique, everybody's equal before the law, and everybody has a right to a fair trial, so we're all equal. So Your Worship, how do we find somebody more accountable on the basis that is the leader of a party, but yet we say we're all equal before the law? And Your Worship said this specific accountability of public officers way much more. It doesn't mean you are not treated equally, and I don't understand that concept. Specifically, Your Worship, when we have regard to the decision that we quoted in our heads of argument in the Constitutional Court, and ironically dealing with the EFF versus the Speaker of National Assembly, where they stated as follows, in reference to the case that did away with the death penalty, Your Worship, and they say, and I quote at paragraph 235, "It is after all the embodiment of the legendary Lady Justice, a dispenser of justice who is blind and deaf to images of any reports on the good reputation and notoriety of personalities before her, but never misses any legitimate and relevant legal or factual points for or against any litigant." So what we're saying, Your Worship, is that justice must be dispensed without fear, favour or prejudice. It's known, it's accepted by Your Worship. That includes Lady Justice being blind and deaf, Your Worship, and not overemphasising the position that a person plays in society when it comes to sentencing them for conduct, which conduct, as we've stated, Your Worship, was over within minutes with respect. May I just have a look at it. Your Worship also went further to say that the accused had been dishonest in his approach to the court, and with respect, Your Worship, there was no basis for that factual finding, particularly in relation to sentence, and this, Your Worship, then impacted on Your Worship's then finding that Your Worship could have regard to corruption cases and fraud cases dealing with dishonesty. And that goes back, Your Worship, to the issue that I raised earlier of being in a position of trust. It seems that reasoning permeated Your Worship's logic or reasoning throughout this matter, and we said that that is a major, irreversible misdirection on Your Worship's part. So in conclusion, Your Worship, what we say is that taking account of the crimes of which the accused was convicted, the interests of society and the personal circumstances of the accused, as well as the unique facts pertaining to this matter, the custodial sentence ought not to have been imposed. The imposition of the custodial sentence is startlingly inappropriate to the extent, Your Worship, that it induces a sense of shock. May I just listen to my colleague?
The police. Please, sorry, can you just a minute? We are returning. I couldn't hear what that last sentence is.
I'm instructed by Rotary to point out, and it's a valid point. If one has regard to the fact that there's never been a case of this nature, and we're all in agreement on that. So this is a novel situation that we seem to be dealing with judicially. So there's no sentence, there's no precedent that one can say, oh, well, the other case is exactly the same. This is what they did for celebratory shots. If you look at Oscar Pistorius, if you look at all the other cases, there were people in a built-up room. He was given a non-custodial sentence for discharging. He wasn't charged with the possession, but it's very similar facts. This could even be regarded as a duplication. Possession, and there are cases that say possession of the firearm, possession of the ammunition is impossible without discharge of a firearm with ammunition is impossible absent the firearm and the ammunition. Why should they be treated separately? And that's the case. Where with Oscar Pistorius, it's common cause factor. He received his friend's firearm. He shot that firearm. He wasn't licensed to possess it. He was thinking of buying one like that. That was the justification. Yet he was only charged with discharging the firearm. Here we have the very, very similar situation. Not only, Your Worship, did the state separate the charges, Your Worship then found him guilty of all three and gave different sanctions, different punishments on each and every one of those three charges, one being a 5-year sentence, Your Worship, with respect. So if we have regard to those and we do a comparative, it cannot with respect be said that this appeal is doomed to predictable failure. It has a very, very strong prospect of success, as we say. So we respectfully request leave to appeal against conviction and sentence, Your Worship.
Caesar, I'm not sure if you already, based on what you've heard, No, there's not. I was. Yes. I realized that's why. Yes. No, you can't. No, I fully agree. I understand. I was thinking. That's why I'm saying. Has he listened, and then does he need a few minutes to prepare a reply? Because I've memorized. I don't require. I've listened. I don't need your working document. You need a few minutes, Advocate Caesar? Okay, thank you.
Section 309 of the Criminal Procedure where leave to appeal is applied from the Criminal Magistrates Court to a high court. Insofar as the leave to appeal application is in respect of conviction and in respect of sentence, one of the factors that has been mentioned, if my memory serves me correct, and counsel can point out to me whether it is inaccurate, that Your Worship failed to take into consideration that the principles in Rex versus Blom relating to the only inferences relating to the incident in question, that the accused did in fact possess the firearm and that he did in fact fire those shots. This was our submission. In that regard, the court took into consideration all the evidence, including the video evidence, which the court deemed to be admissible, and like I've already said previously, that was enough evidence for the court to come to that particular finding that the accused did indeed fire that particular shot, and that there are no prospects of success relating to the conviction and sentence in this regard. If we deal with applications for leave to appeal, I've heard counsel say there are good prospects, but that's not the only requirement. The mere possibility that another court might come to a different conclusion is not enough to convince the trial court to grant leave to appeal. The reason for that, why the courts have taken such a view, if Your Worship is of the view that the conviction was correct, allowing an application for leave to appeal will absolutely amount to a waste of judicial resources when there's no prospects of success. I submit that counsel might have an arguable case, but if there's no realistic chance, insofar as the conviction is concerned, that he will succeed. It has been pointed out in so many cases, the Supreme Court of Appeal has stated what is the test of reasonable prospects of success, postulates it's a dispassionate decision based on the facts and the law, that the Court of Appeal could reasonably arrive at a conclusion different to that of the trial court. In order to succeed, therefore, the appellant must convince the court on proper grounds that he has prospects of success on appeal and that those prospects are not remote but have a realistic chance of succeeding, most required to establish than that of the mere possibility of success. A mere possibility of success, an arguable case, like I said, or one that is not hopeless is not enough. This is basically what I said counsel have argued before, Your Worship. There must be a sound, rational basis to conclude that there is a reasonable prospect of success. Insofar as the sentence is concerned, that before I go there, I just want to say the court has thoroughly considered all the evidence. Like the court pointed out earlier, the court had a long judgment dealing exactly with every issue that has now been raised by counsel, whereas the court has made those findings in respect of each of the points raised. It's my submission, insofar as the conviction is concerned, there is no reasonable prospect of success and no realistic chance that it will be overturned on appeal. Insofar as the sentence is concerned, Your Worship is of the view that I did request that the 15-year sentence must be imposed. I also provided alternative sentences which might be imposed to the accused. I'm satisfied with the sentence that was imposed by this court. As a matter of fact, I find it to be fair, and regarding to the facts of this case, there's also no prospect of success relating to this particular sentence, that the different court will come to a different conclusion, and that the court should dismiss this application. The issue with bail, I will deal with, Your Worship, as we go along, depending on the court's finding whether there are indeed prospects of success or not. Thank you.
Start out with the arguments made about the correct test. It seems that my learned friend wishes us to argue that your worship is wrong, but we don't have to argue that you are wrong. It is on appeal that we will argue that you are wrong. What we are dealing with today is merely a question of whether there is a realistic probability that another court might come to a different conclusion. In other words, is there a realistic prospect that that will be the case, both on the questions of fact and on the questions of law. So it's crucial to underscore that test. And the exercise is also not a repetition of the case that your ladyship has had. Your ladyship is now functus officio in relation to your judgment. So we don't have to persuade your ladyship that you were wrong. We simply have to show that someone else looking at the same facts might come realistically to a different conclusion. The only argument made by the state, and it's important to examine their case, what they have said now, is around R versus Blow. That's the only thing they have said. Now, your ladyship, if you contrast that with the case that has been made on behalf of the accused, R versus Blom is one aspect, but there are so many other grounds for leave to appeal that have been advanced. The reality, your worship, is that none of those have been responded to. What you have is just a generic submission that there is no reasonable prospect of success, and there is no reasonable likelihood that a different court looking at the different facts might arrive at a different conclusion. So in effect, you are then not dealing with an application on conviction that has been seriously contested by the state. They've raised only one ground and they've ignored each and every ground, and they've put them under this omnibus category that there is no reasonable prospect. So that's point number one, that actually this is not meaningfully opposed by the state. Point number two is that what that does is that it therefore leaves those grounds uncontested. Now, that has serious implications then for your worship's weighing an assessment. So if you have an accused person that gives you 10 grounds, and we've got the NPA that responds to 1 ground, and that leaves 9 grounds unopposed in effect. What does that then do to the court? Is the court now supposed to fill the gap left by the state? I'll tell you why they have taken that approach. It's because they themselves accept that this is a strong application for leave to appeal on fact and on law. So if that is the case, then that the only logical deduction to be drawn from the unserious opposition is that actually this is a cogent application for leave to appeal. Then it leaves your leadership's role very easy, because you don't have to decide whether you were right or whether you were wrong. Someone else must decide that. The job is very easy. The High Court must make a fresh evaluation of the evidence and make a determination whether the convictions were safe or not. That then takes me to the question of sentence. We have a similar approach taken by the state. This is what they said. I noted it down. They say, we've asked for 15 years, we've got 5 years in one and 2 years in the other. We are very happy with that. Of course they are. But the question is whether there is a realistic chance that someone else looking at these facts might arrive at a different conclusion, or whether or not there is a reasonable likelihood of success on the appeal of the sentence. If I have to weigh, and I'm not doing that weighing now, the 2 appeals, the conviction and the sentence appeals, I would say the sentence appeal enjoys the most excellent prospects of success. One, because you are not dealing with a field that is occupied by judicial precedent. And it is correct as a matter of law, if you are not dealing with a field that is occupied by consistent precedent, to say the higher court must relook at it. And that is not because your worship is admitting that you were wrong. Your worship is simply saying there are different views in this field of law, and let the higher court relook at this and make a determination. Just take one example on the discharge alone. Look at the 4 cases we looked at yesterday, if you remember all of them, your worship. You know, none of them resulted in direct incarceration, none, 0. And you look at the case presented by the state, they are unable to point to a single case of a discharge that results in direct imprisonment or discharge alone. Then you look at your leadership's finding, count 2, which is the discharge count. You sent Mr. Malema to 2 years direct imprisonment. Now, can you be confident that there is no other court that realistically may come to a different conclusion? I think that if you took that view, your leadership would probably fall into an error. Even if you look at count 1, the possession charge, it is correct what my learned friend said, that these cases differ. Yesterday I took your lordship to 7 different authorities. I picked 3 where there have been fines of as low as 2,000 rands in circumstances where there have been injuries. So even that, an imposition of 5 years is not a safe direct incarceration, no option of a fine, no suspension. It's not necessarily a safe imposition. So it would be proper for your leadership to say, look, I've done my job. Now let the High Court relook at this matter and decide what it wishes to do. I'm not going to complain about the declaration that Mr. Malema is not fit to possess a firearm, because it follows from the convictions. If those convictions stand, then there's no problem with that. But if those convictions, there's a realistic chance of setting them aside, then as a matter of logic, the balance follows. So what am I saying then on sentence? I'm saying to your leadership that it is possible that someone else, realistically possible, that someone else will say this sentence induces a sense of shock. Now we can say that, my lady, without fighting with your leadership about who introduced politics in court. We can say that purely on judicial precedent. And we can say that purely on application of legal principles. And when your leadership considers this, your leadership we accept will be dispassionate, and your leadership will be blind to the politicians sitting behind me, and will be looking at the accused without identity, and then decide, well, does he deserve to have his case re-evaluated by a higher court or not? Now, if your leadership even refused that, then we will say that your leadership is not acting in accordance with the oath of office. But we trust your leadership that you will act in accordance with the judicial oath of office and send the matter to the High Court, let them re-evaluate it. They might agree with your leadership, but there have been many instances before that you think you are right. I've been there myself. I think I'm right, and then five judges sitting in the Supreme Court of Appeal say, sorry, acting judge, you were wrong. And that's where we are today. Your leadership may be overturned. And so we ask, therefore, with respect, this is a discretionary matter, but at the same time, it is a matter of application of settled legal rules. So we would therefore ask that you send the conviction, you send the sentence to the High Court, as you please. I just responded to a political speech.
Yeah. Okay. I think we can return before 1. Since I've heard what you've said, Advocate Ouders, and thereafter Advocate Mqaitobi and Advocate Caesar. It's not a difficult issue as you've stated. The law is clear. I'm going to extract the relevant parts and return, can we say 12:30? That will give me sufficient time. Please, just a minute.